in the matter of Curless and Shell International Limited, part heard.
Please, your lordships. Before moving on to the final topics, I just wanted to make a couple of observations on some of the references I gave yesterday. If I could start first with the Gamlin case at Authorities Bundle tab 6. If the court could please go with the transcript to page 13.
Yes.
And at letter, just above letter F, where Lord Justice Gough says, I wish only to add two further observations. First, the court must in every case, of course, be satisfied that what is prima facie proved really is dishonest, and not merely disreputable or a failure to maintain good ethical standards, and must bear in mind that legal professional privilege is a very necessary thing, is not likely to be overthrown. But on the other hand, the interests of the victims of fraud must not be overlooked. Each case depends on its facts. And of course that reference to every case must include the case presently before the Court of Appeal in that matter. And in those circumstances it's difficult to see why, and I'll come to this in a second, why Sir James Mumby was subsequently of the view that the passage at page 13 I've just read in Gamlin was obiter. Of course, those were remarks which, as we'll see in a moment, were themselves obiter. It's the references to the Kerman or Z and Z case at paragraph 62 of Mr. Halliday's skeleton. And just recapping on what I'd shown the court yesterday, as counsel in Gamlin, Mr. Mumby had submitted that fraud and dishonesty were required to displace privilege, his client's privilege, relying on Lord Justice Gough's own first instance judgment in Crescent Farm. And we say, looking at the passages I showed you yesterday, that Lord Justice Gough agreed with him, not resigning from, but rather approving his own judgment in that case. And Lord Justice Gough also went on, he also agreed with the first instance judge that the case was on the Williams and Cabrada side of the line, whereas we saw yesterday the touchstone was commercial dishonesty. So taking his judgment in the round, Lord Justice Gough must be taken to have held that Mr. Mumby's clients had been dishonest, and held that dishonesty was a necessary finding to trigger the application of the crime fraud exception in that case. And just looking at the Z and Z case, if we go, please, to tab 27 in the same bundle, we don't need all the facts. Perhaps if the court has that behind tab 27, we could just look at, on page 2 of the report, page 2 of the report, looking at the numbers at the bottom, holding 2, third of the way down. Perhaps the court could just read holding 2, that the law related to legal professional privilege. This is the point, really, that my Lord Justice Lewison made to me yesterday. It summarises it neatly.
What the wife was after was the whereabouts of the art collection,
yes,
and the insurance arrangement for it,
yes,
which Mr. Kerman had organised.
What the decision ultimately didn't require any consideration of the crime fraud exception, because essentially the relevant communications, there are a number of reasons, including that the lawyer was acting as a man of business rather than qua lawyer in this case, but the critical reasoning was that the communications were third-party communications rather than lawyer-client communications. And with that, one sees the observations at the end, paragraph 54, the penultimate page of the judgment, where perhaps the court could just look at skim read paragraph 54, where one sees Mr. Shepherd's complaint. the judgment below. And then at 55, Sir James Mumby says there's no need for us to decide any of these points. It's better that we do not. I confine myself to two observations. The first relates to the decision in Gamlin. It's clear reading the transcript as a whole. The entire argument proceeded on the assumption that what had to be established was fraud or dishonesty. Just pausing there, we say that's the correct analysis. Just as it's clear, having regard to the structure of the judgment, that the crucial passage of Lord Justice Goff's judgment upon which Mr. Shepherd relied was obiter, and you have my submissions on why we submit it wasn't. And then he says, his lordship says, the second observation relates to Eustace. Even if the test is correctly dishonesty and not merely iniquity, it does not follow that the actual decision in Eustace was wrong. And then he cites from an average textbook, and we respectfully agree with his point about Eustace on the facts not being wrong, even if dishonesty was the test. And then he goes on after the citation to say, given the decision in Williams and Cabrada, which, so far as I'm aware, has never been questioned, it's not easy to see why the actual decisions in Eustace in relation to section 423 of the Insolvency Act and in C&C in relation to section 37 of the Matrimonial Causes Act should be questioned, whatever criticisms there may be of some of the reasoning. And again, we agree with those observations by Sir James. Now, I envisage from the discussion we had yesterday...
So I can just summarise it, because you've read the passages you asked us to read.
I'm obliged.
And would I be right in thinking that the pithiest statement that encapsulates your position on this at the highest level would be that of Lord Sumption in Prudential, where he basically says it's Gamden, and he cites Derby magistrates and so on. I mean, that's your central point, is that the privilege principle is absolute, subject to a very limited exception.
Yes.
And one thing it does not involve weighing up considerations of public policy, because that undermines the very concept of the absoluteness of the privilege.
Yes.
I mean, that's the centre of your...
That's the centre of it.
And you say you've got support for that at the House of Lords level.
Yes, but if I need to, I would go further and say that if one looks at Barclays Bank and Eustace, it cites Scamlin, but it doesn't purport to interpret it in a way which is binding on this court. Lord Justice Lewison, my Lord Justice Lewison, summarised our position very well yesterday in terms of the tension between a public policy-based approach and the approach in Derby Magistrates Court, as followed in Three Rivers 6 and applied in the Auckland decision.
Mr. Thinker, what do you say is the ratio of Eustace, if it has one?
The essential ratio was that there was a fraud within the meaning of section 423 of the Insolvency Act. That Mr. Eustace had acted so as to defraud his creditors within the meaning of that section. And we say that to the extent that Lord Justice Sheepman went further, the remarks are obiter and contrary to Gamlin.
The trouble is that fraud here, I think you would accept, encompasses more. I think it encompasses more than simply a dishonest design. Is that right?
No, I don't accept that.
So you say the fraud here is limited to dishonesty.
Yes, and we get that from going back to the earliest, the origins of the crime fraud exception in Cox and Railton, where in the passages I showed your lordships yesterday, dishonesty is effectively equated with fraud.
But in that case, is it right that fraud is actually otiose here? It's all about dishonesty, and reference to dishonesty or fraud you would say is misleading.
Fraud is normally equated with dishonesty. There are some rare exceptions, like equitable fraud, for example.
That's what I'm trying to understand.
But fraud is generally equated with dishonesty. But for the purpose of the crime fraud exception, I would accept that fraud means dishonesty. And that's my
How
submission.
does that then mean? So how do you then deal with the question of equitable fraud, which is certainly one of the matters that was mentioned, which does not necessarily involve dishonesty? Do you say that it's only equitable fraud which involves dishonesty which comes within the exception?
I would
So it's
say
only equitable fraud which involves dishonesty.
Yes, I would submit that.
And so you wouldn't accept a test, would you then, or would you, of those matters which business people would consider to be outside the dealings of an honest person? Is that too wide, or how would you use that particular formulation of what business people might think?
It would need to satisfy the test of dishonesty.
Well, it's what reasonable business people would consider to be dishonest. Is that what it would be?
Yes. One would apply the Ivy and Genting test. One would apply the Ivy test for dishonesty.
So you said something test. I didn't quite catch that.
Ivy.
Ivy.
Which is the latest pronouncement of the House of Lords on the definition of dishonesty. It's essentially a subjective standard.
Right.
I'm obliged. And just to pick up the reference in Derby Magistrates to Eustace at bundle A12, which I envisage the court will have looked at, but just if we could just turn it up. Page behind tab 12, and page 509 in the speech of Lord Lloyd. It's the only reference to Eustace we see in the Derby Magistrates Court case. And if you look just above letter G at page 509, you see that Lord Lloyd says, Mr. Goldberg argued that times have changed and that greater emphasis is now placed upon the court being put into possession of all relevant material in order to arrive at the truth. But the principle remains the same, and that principle is that a client must be free to consult his legal advisers without fear of his communications being revealed. Cox and Railton provides a well-recognised exception, otherwise the rule is absolute. And then over the page, at 510, just above letter B, Lord Lloyd says, the judgment of Lord Justice Sheeman in Berkeley's Bank and Eustace came too late for our consideration. In any event, Mr. Goldberg abandoned any argument based on the Crown and Cox and Railton.
Yes.
And BBGB, I gave you the reference to yesterday at paragraph 62. Our essential complaint about paragraph 62 of BBGB, which Mrs. Justice Slade relies on, was that it treated public policy as a freestanding concept which could vitiate privilege, as opposed to the stricter test which we advocate to your lordships. And although Mr. Justice Norris said he was drawing on Williams and Cabrada and Gamlin for that proposition of public policy, it looks like it's simply drawing on Eustace, which he also cites. So with that, I was going to turn, and I'm going to deal with this as briefly as possible in the light of your Lordship's observations yesterday. I was going to deal as briefly as possible with the extent to which the court needs to be satisfied that the crime fraud exception applies, and we develop this in our written submissions at paragraphs 59 and following. And the reason I would like just to spend a few moments on this, and I will cut short and give you references rather than taking you to every case I was planning to take the court to. The reason I would emphasise this is that it is an essential requirement of the crime-fraud exception that the communications, which are said to be caught by the exception, have to be in furtherance of the fraud. That's an essential requirement. And just to give you some references without turning up the cases, your lordships can get that from O'Rourke in the House of Lords at Authorities Bundle tab 3, page 613 in the speech of Lord Sumner, and also from the Crescent Farm case in the judgment of Mr. Justice Goff, the next tab in the Authorities Bundle tab 4, at page 564, letters E to F. So even if, against that background, even if one thinks that Mrs. Justice Slade's interpretation of the email is correct, one still needs to be satisfied that it was sent in furtherance of a fraud. And we say against that background, given that it's an issue, that the genuineness of the redundancy process is an issue in the underlying action, extreme caution is required in this context before finding that the crime-fraud exception is made out. And just to give you some references without turning up the cases, as to the exceptional nature of the crime-fraud exception, Derby and Weldon, number 7, which is Authorities Bundle, tab 9, at page 1174, letter E. And then in the Court of Appeal in Butts Gas, Authorities Bundle, tab 7, in the judgment of Lord Denning, at page 246.
You've given us all these references in your footnote.
I was trying to give you more precise references, including the letters, so it's letters G to H, where Lord Denning says that the fraud must be obvious. And the only case I wanted to turn up in this context was Kuwait, and I'll try and take this briefly. Kuwait Airways, Authorities Bundle tab 17.
Is it going to add to what you quoted in paragraph 61?
I can't remember what I quoted in paragraph 61. It does a bit, yes. It just gives some colour to... but there's only about 3 or 4 paragraphs I want to take. I'll do it shortly. In due course, if the court could glance at the head note, I won't take time up on it now, but one can see that the facts of Kuwait Airways were fairly extraordinary on the basis that there had been prior judgments which had held that there had been fraud. So it was an easy conclusion to reach. But if we go, please, in the judgment of Lord Justice Longmore at paragraph 36, and he refers to the Hallinan case and other cases. He says that these show that the fraud exception can in principle apply even when litigation has begun, with the result that privilege will not attach to documents which further the fraud or the criminal purpose. They also show that courts will be cautious about ordering disclosure or inspection of such documents. That caution has 2 aspects. One, it may be unfair to a defendant to make such an order if all that is shown on the evidence is a prima facie case which may turn out on full investigation to be incorrect. And 2, it may be unfair in what Lord Justice Glidewell in the Snaresbrook case called the ordinary run of cases, such as cross-allegations of assault or drivers falsely saying they were driving on the correct side of the road, to order disclosure and inspection merely because communications with the party solicitors are untrue and would, if acted upon, lead to the commission of the crime of perjury. And one can see a resonance with paragraph 59 of Mrs. Justice Slade's judgment there. If acted on, she says it would lead to the deception of a future tribunal, etc. One can see a resonance there of the way in which Lord Justice Longmore deals with it. And 37, these two reasons for caution are, of course, somewhat interdependent. If all one has is a disputed version of events, it would be difficult to say that there is even a prima facie case of fraud. This would be particularly so if the disputed version of events is the very same issue that is to be tried in the proceedings. And one of our complaints about Mrs. Justice Slade's judgment is that it presupposes intentions on the part of my clients which are at issue in the underlying tribunal proceedings. If, however, the evidence of crime or fraud is freestanding and independent, and particularly if its evaluation does not require any judgment to be reached in relation to the issues to be tried, and he refers to the Hallinan case, it would be perfectly possible, even on a prima facie case basis, to decide whether the fraud exception applies. At 38, it's significant that in Chandler and Church, there's only prima facie evidence of fraud, and the fraud was alleged in relation to the issues that had to be tried. Mr. Justice Hoffman refused to order disclosure. By contrast, in Dubai Aluminium, where the alleged fraud did relate to the issues to be tried on the application to discharge the search and seizure order and the freezing injunction, Mr. Justice Ricks, following Eustace, thought that before disclosure was ordered, there should be a strong prima facie case of criminal or fraudulent conduct. He held on the facts there was, therefore ordered disclosure. And then finally, if we go to 41, paragraph 41, if fraud exception cannot be relied on where there has been a final decision of the court, that an earlier decision of the court has been procured by fraud, perjury and a conspiracy to pervert the course of justice, as it happened in this case, it would be difficult to think of any circumstances where it could be relied on once litigation was contemplated or begun. Once it's established, as I would hold, that the fraud exception can in law apply in such circumstances, it would be a travesty if it did not apply in the present case. And then we can go on to 42. Therefore, summarise the position thus. 1. The fraud exception can apply where there is a claim to litigation privilege, as much as where there is a claim to legal advice privilege. 2. Nevertheless, it can only be used in cases in which the issue of fraud is one of the issues in the action, where there is a strong, I would myself use the words very strong, prima facie case of fraud, as there was in Dubai Aluminium, and there was not in Chandler and Church. 3. Where the issue of fraud is not one of the issues in the action, a prima facie case of fraud may be enough, as in the Hallinan case.
Thank you.
And that's all I wanted to say on that topic, and I was going to turn then to the pub conversation.
Right, I think what we're going to do is we'll hear Mr. Holliday first on his submissions on the application of the exception to the privilege principle on the email.
Yes, before Mr. Halliday rises, I did want to say a word or two about the application to admit fresh evidence, just so that my client's position is clear, but I can do that at a convenient point.
I think we better hear you on that now.
Very well. First of all, the application, as the court knows, came in very late, and on any view it's an unusual application. The court will recall the background to the present appeal. The claimant was given evidence that an anonymous benefactor provided him with the email of the 29th of April that is at the heart of the dispute. And the email was said to have been received by him in the post in or around October 2016, with a covering note at the bottom of the email that he has no information about who sent it. Now what we have seen is a fresh witness statement saying that a further batch of prima facie privileged documents concerning his employment status was sent to him by an anonymous source in late September, apparently bearing a Gatwick postmark. and he says that he first opened the package last Sunday evening, that is the 29th of September, 2 working days before the present appeal, returning to his home after a period of absence, presumably on holiday. The further batch of documents was accompanied by a covering note that appears to have been written in the same hand as we saw at the bottom of the 29th of April email, and both are signed off with an X in the same form. The claimant's apparent evidence, he doesn't know who sent this further batch of emails and covering note. Looking at the content of the covering note, it appears that the author is making clear that he or she has little knowledge of the present proceedings and was only relaying the documents having come across them fortuitously in the course of a clear-out, as it's put. It's therefore a striking coincidence the document should have been sent to the claimant a matter of days before the appeal. Now, although the company has not been able to formulate a formal response to the application given its lateness, it submits that the application raises 3 questions. First, are the emails ones that the claimant could not have previously obtained, applying the first limb of Ladd and Marshall? Second, if so, are they privileged? And 3, if not, are they relevant? And I will take those 3 questions in turn quickly. First of all, as to admissibility, the manner in which this fresh batch of emails is said to have come into the claimant's possession inevitably invites a degree of surprise. Yet another unauthorised leak of material from someone who says that they have left the company. However, for the purpose of this appeal only, the company, my clients, are content for the court to proceed on the basis that the first limb of Ladd and Marshall is satisfied, that this evidence could not have been obtained with reasonable diligence until shortly before the hearing. The next question then is whether the documents are privileged. The claimant does not appear to dispute that each of these are from or were copied to at least 2 lawyers and are clearly marked, all of them, in some form or another legally privileged and confidential. In the premises, the company would respectfully submit that the starting point is that the emails are privileged, absent some compelling argument to the contrary. In that respect, it's notable that the claimant does not appear to contend that the emails are themselves subject to the crime, fraud, iniquity or iniquity exception. Instead, the analysis given in this application is that they don't concern legal advice at all, and that the lawyers were acting in non-legal capacities. We say that that argument is hopeless. First, where trained lawyers describe their communications as privileged, there's no obvious reason to doubt that this label is correct. At least that should be the starting point. Second, even on their face, it's clear that the emails have been taken from a longer chain, such that the claimant's assertion as to the true nature of the exchange is not an informed one. It's simply speculation based on an incomplete set of documents. Third, in the short time available, my clients have analysed the longer chain of emails as of high, from which this batch of emails has apparently been cherry-picked. Without waiving privilege, the company has considered the email chain in the light of the application and maintains its assertion of privilege. The wider chain shows that the overall purpose of the flow of information was to give instructions to and to obtain legal advice from in-house counsel. In the ordinary course, that claim to privilege would be conclusive of the position see Darby and Weldon number 7 at 1179 to 180. Fourthly, and in any event, the claimant's allegation to the contrary raises a host of evidential issues that, if they are to be entertained at all, simply cannot be addressed in the course of this hearing by this court. In the premises, the company's position is that the emails are privileged, indeed we say clearly so, and that the claimant does not raise any good basis for its assertion to the contrary. The third question is relevance. There is, we say, a further reason for rejecting the present application based on relevance. The claimant's application is not for an order that the documents be admitted in the underlying employment proceedings, but rather for an order that documents be admitted for the purposes of this appeal. On proper analysis, these documents are not relevant, we submit, to the matters before this court. We recall that the second limb of Loud and Marshall requires an application to adduce new evidence is such that new evidence would have an important influence on the result. It was recently held by this court in a case called the National Guild of Removers and Storers against B Move Limited. In this instance, it is difficult to see that the proposed evidence would have any bearing on the court's analysis, let alone an important one. Specifically, timing, the emails that are the subject of the application date from December 2014 to the 6th of January 2015, whereas the key email considered by Mrs. Justice Slade, and which is the subject of the present appeal, is dated 29th of April 2016. So well over a year later. Authorship, the emails in the application are written by different people, none of whom was even a party to the 29th of April 2016 email. Accordingly, it's very difficult to see how emails written by two individuals in December 2014 into early January 2015 could be sufficiently relevant to the construction of an email written by another individual 15 months later. In the company's submission, that's the end of the matter. These emails are simply not relevant to the matters at hand. But just standing back, underlying the claimant's application is some sort of suggestion that there is some sort of conspiracy to discriminate against Mr. Curless, which goes far wider than that previously alleged. Now appears to allege that the conspiracy against him covered the whole period from at least December 2014 until his dismissal in January 2017. And the parties to the alleged multi-year conspiracy must now go beyond the parties to the 29th of April 2016 email and include at least two further individuals who wrote the emails that are the subject of this application. We submit that this is fanciful. It's not something that this court or any court can realistically be invited to determine on an interlocutory basis. And it's in effect seeking the court to make preliminary findings about almost the entirety of the underlying proceedings against a range of named employees of the company, at least three of whom are trained lawyers, on the basis of an application made on the eve of this hearing. But as I said yesterday, whilst maintaining our claim to privilege, we have no objection to the court looking at the emails de bene esse. But I am very keen to emphasise that the company does not intend to make any waiver of privilege, either over these documents or any collateral waiver. But my client is content for this court to consider the submissions, having looked at the relevant emails that Mr. Halliday relies on.
Thank you very much. Thank you very much. Yes, Mr. Halliday.
My Lord, just by way of a roadmap, I intend to make my submissions, which are going to exclude at this stage the pub conversation, in four parts. First, picking up where we've just left off, I propose to get my application to adduce the fresh evidence out of the way. I appreciate your Lordships have said you're willing to look at the new materials de bene esse and that you're likely to reserve your decision on the application to admit them until you give your judgment on the appeal. Nonetheless, I need to deal with the application at some point during my submissions. I propose to do so at the outset. Secondly, I would like to highlight several key features of the factual background, which I say are relevant to the correct interpretation of the April 2016 email. Thirdly, I plan to address the first ground of appeal, which is essentially what does the 29th of April 2016 email mean? And fourthly, I plan to address you very briefly on the third ground of appeal, which concerns the legal issue of what does and what does not count as iniquity for present purposes. And in the light of Mr. Tankey's concession yesterday that if Mrs. Justice Slade's interpretation of the email was correct, then the iniquity principle should apply, I can take those legal submissions relatively shortly. May I take it that your Lordship still have a copy of the application in front of you?
The application, yes.
Now, as a preliminary remark, Mr. Tankey made a complaint about the timing of the application. And ordinarily, were an application for fresh evidence to be made the day before an appeal hearing, one would have considerable sympathy with that complaint. But not so in the circumstances of this case, I say, for reasons which I shall explain. The circumstances in which
Well, I
we
don't think Mr. Thankey was relying on that as a ground for objecting to the application. He was accepting that the first level martial requirements were satisfied.
he did, but he made preliminary comments about how the
Yes,
timing
but
of
it wasn't an independent ground of objection.
it wasn't an independent ground. I was going to reply to it very briefly.
It was more of a whinge, I'm afraid.
I'll take it extremely shortly in that case. No blame can be laid at Mr. Curless's door for the lateness. He only saw the emails for the first time on Sunday night. If, as I'm going to submit, they're not subject to legal professional privilege, it's the company which should have disclosed them to Mr. Curless in the underlying proceedings. There's been an order for disclosure and they weren't provided. So I say that the timing really lies at the door of the company, not the claimant. I propose to address the relevance and the legal professional privilege points somewhat more forensically than Mr. Tankey. Could I take your Lordships to the emails themselves, please? The chain of emails appears in reverse chronological order. So they start with page 6.
Now, where are these two found?
They're attached to the application notice.
Okay. Yes, thank you. Well, I've got there's a witness statement, attached to the witness statement, that's it.
Oh, great.
Thank you. Yes.
So the first email in time is an email dated December 2014 from Eleanor Silverio, who was an HR advisor, and it's sent to Alex Wade, who is a lawyer, and to Pamela Nelson. And Pamela Nelson is also a lawyer, but she was also the claimant's line manager, and we say that in these emails she's clearly acting in her capacity as the claimant's line manager, not in her capacity as a lawyer giving legal advice. Have your Lordships read this email, and if not, can I ask you to do so now, please?
I hope you've all read all the emails. Would you like us to read them again?
No. If you've read them already, I don't see the point.
So sorry, I was on the wrong page there. So Eleanor Silverio was a lawyer, but you say acting as the line manager.
No, Eleanor Silverio was an HR advisor and not a lawyer.
Sorry, Eleanor Silverio was I'm so sorry, got this wrong. She was the HR. Yes.
Alex Ward was a lawyer,
Yes.
and I don't make any submission that she was acting outside her capacity as a lawyer in these communications.
Right.
Pamela Nelson was a lawyer,
But also,
but she was also the line manager, and I say she was acting here in her capacity as the line manager.
yes, thank you.
And who's Kim Lennon? May not matter.
Kim Lennon is another HR advisor.
Right. Thank you.
Now, the first question which arises is whether this email is or is not protected by legal advice privilege. And Mr. Tankey is right to say that I don't rely in this respect on the iniquity principle. In fairness, I would accept that the penultimate paragraph, reading Alex, as always grateful for your view, is protected by privilege. because it's a request to Alex Wade, the lawyer, for advice. But the bulk of the email, in particular the series of bullet points, is not a lawyer-client communication. Your lordships have read it. It is plainly HR advice from an HR advisor to Ms. Nelson, acting in her capacity as the claimant's line manager. So I say that long section which forms the bulk of the email, beginning Pam as next steps would suggest the following, and ending with the final bullet point, is not a lawyer-client communication.
Well, surely it falls squarely within Air India and Balabal. It's just saying this is what we suggest we should do going forward. Lawyer, what do you think?
No, with respect, my lord, that passage begins with the word Pam.
As next steps would suggest. So this is the suggestion, and they're asking the lawyer to give a view on the suggested course of action. And isn't that exactly what Air India and Balabal says comes within the scope of legal advice privilege?
It would if it was addressed at the lawyer, but that passage
Well,
is
it is in respect. She is the first recipient from Eleanor Silverio to Alex Ward.
My lord, the relevant passage begins Pam, as next steps would suggest the following, and Pam is the line manager.
Well, is that what it means? I mean, is it not recording what Pam is suggesting? Pam would suggest.
My lord, if you read the full chain of emails, I think it's reasonably apparent that this is the advice from the HR advisor to Pam, and Pam then responds to that advice subsequently.
Anyway, right. But if somebody sends, if somebody in a company sends a message to two people, one of whom is a lawyer and one whom isn't, and they ask for the lawyer's view on the matters that are set out, why shouldn't that fall within why shouldn't the document fall within the scope of the privilege?
Because the predominant purpose of this email is to give HR advice to the line manager. There's one short line at the end which says, really by way of an aside, Alex is always grateful for your view.
But I mean, in terms of the amount of the space on the page that's taken up, of course you're right that most of that comes under the rubric Pam. But why do you say the predominant purpose is such? I mean, if you're suggesting a course of action, then you ask a lawyer to comment on it. Why wouldn't that legal advice be equally important, if not more important?
My lord, it's well established that a part of a document can be privileged, with the remainder not being privileged. And in my submission, that passage with the bullet points is really exclusively directed at Pam. It is HR advice to her.
What is Alex being asked to express? What is Alex being asked to express his view upon?
She's asked to express her view on those points, and I accept that line of the...
Can I encapsulate your point in this way, being neutral, trying to be fair and neutral about it? You say that the predominant purpose of this message is to seek HR advice, and if that is correct, then even though it's also directed to the lawyer, it falls outside the privilege principle. Would that be a fair summary?
That's a fair summary, my lord.
Thank you. Yes.
Now, as to the question of relevance, the full relevance of this chain of emails becomes more apparent as we get to the end, but the relevant passage in this one is the final bullet point. Going forward, I believe we will need to put Mike on a performance improvement plan. His performance is inconsistent and generally poor. I recognise that this will be difficult, but suspect that if we start this procedure and keep the pressure of a potential release due to poor performance, he may accept leaving by way of some type of release more easily, or who knows, he could start to take his performance more seriously. And what I say this clearly discloses is that the company had already, by December 2014, formed some desire to terminate the claimant's employment, to pressure him into leaving on account of his performance.
This is before the first allegation of discrimination, isn't it? So that this can't be victimisation.
That's correct. Next in time is the reply at page 5. Again, on the initial question of whether it falls within the scope of legal advice privilege, I say that this one, despite the fact that Alex Ward is named as a recipient of the email, is in truth exclusively a communication between Ms. Silverio and Ms. Nelson. The substance of the email is entirely, if your lordships have read it, a request for HR advice from the line manager to the HR advisor. Indeed, we see at the start of the email itself, it's addressed only to the HR advisor, Hi Eleanor, and not to Ms. Wade. Could I ask your lordships to reread the first 2 paragraphs of the email, please?
Yes. Yes.
And the particular part I rely on is, as we've discussed in the past, this is the line manager speaking, I still think a performance improvement plan would be more difficult to manage than what we would get out of it. Mike can certainly keep his performance just above the point of dismissal, so I see this route as a lot of work for very little reward. And that, I say, is relevant because even though the claimant's performance was the reason why the company here wanted to end his employment, it shied away from any proper process to dismiss him for performance reasons because of its view that to do so would be difficult, and because it recognised that his performance was unlikely to justify dismissal. And indeed, precisely because his performance was likely to remain above the point of dismissal, this would be a route with little reward. The absence of reward apparently being the inability to dismiss via this route. Now, on page 4, we have the HR advisor's reply. And really, I'd say that this discloses an even stronger case of a communication which in substance is exclusively between the line manager and the HR advisor, even though Alex Ward is again on the email recipient list. Could I ask your lordships to reread the first and last paragraphs, please? So again, in the body of the email, it's addressed exclusively to Pam, not to Alex. And indeed, we see from the final paragraph that Alex is away. And as to the substance, what does the HR advisor say here? about the line manager's observation in the previous email that the performance improvement plan would be difficult. This is the first paragraph of the email. She says, I understand your position regarding the performance improvement plan, but ask, what would your alternative preferred way of action? In early conversations, Mike indicated that he would not be willing to accept any financial package from the company. And that's clearly referring to a financial package to agree the termination of his employment, unless it's significantly higher than the standard offering. And as that is a non-negotiable route, I think the pressure of a performance improvement plan, alongside a potential medical any other reason outlet would seem to refer to his departure from the company, will be the only way forward, unless of course you've reconsidered following a reorganisation route. Maybe worth looking at that again. So the crucial part here is reference to considering a reorganisation route again. And I say plainly that means using a company reorganisation in order to terminate the claimant's employment, when we can see that the true motivation is his performance.
But if there is a company reorganisation which is a genuine one, why does that render redundancy illegitimate, let alone dishonest? Merely because the employee appropriate for redundancy is aggrieved, is aggrieved and is not performing according to the company's standards. Is one precluded from making such a person redundant?
My Lord, in answer to your first question, in two possible ways. When a company reorganises itself, it's not automatic which roles are going to become redundant and which aren't. Decisions have to be made as to which roles are going to be redundant. And if a company wants to get rid of someone through a reorganisation, it can decide to make his role redundant in the redundancy. So that's the first way in which reorganisation could be misused for ulterior motives.
Yeah, I'm not suggesting it can't be misused. I'm asking whether it's always wrong. It's inevitably wrong if you have somebody who is underperforming and you prefer them not to be there, but there is a genuine redundancy that can be, a genuine wide redundancy process. Is it always wrong to select that person for redundancy?
It is not, but the circumstances of this case are a little more nuanced.
That's all that matters to be determined at the trial. That's the whole thing that's an issue in this case.
Well, there's a strong prima facie case that Mr. Curless's underperformance was a consequence of his disability.
Understood.
And if an employer in your posited example, my lord, were to decide to use a reorganisation in order to get rid of an underperformer, and that underperformer's performance was a consequence of his or her disability, that would be prima facie unlawful discrimination under Section 15 of the Employment Act 2010.
Yes, understood.
Now I say prima facie because Section 15 discrimination is unique in that there is a defence of objective justification. If an employer has an underperforming disabled employee and dismisses that employee on account of poor performance, which is a consequence of disability, it may be justified to do so if it's, quote, a proportionate means of achieving a legitimate aim. But in practice, to be a proportionate means of achieving a legitimate aim, the company is going to have to deal with the matter head on. It's going to have to recognise the influence of the disability on the performance. It's going to have to take medical advice on the prognosis and on what reasonable adjustments can be made to help performance. The company in this case didn't do any of that.
Well, that's in dispute. We've been taken to the defence, and the defence disputes that. They say they did make various offers which were not taken up, and various arrangements were made, or at least offered. I mean, that's what's on. they may not, you may say, as a matter of fact, but that has to be established at the hearing, at the trial.
I don't dispute any of that, but the fundamental point which I'm trying to make is that in these circumstances, where there was no attempt by the company to justify dismissal based on performance, no attempt to get medical advice in relation to the dismissal, and none of that is in dispute, the company has no chance at all of showing objective justification for the purposes of Section 15 of the Equality Act 2010. It is, in my submission, a slam dunk.
That's obviously going to be an issue at the trial. Are you saying we have to determine that on this interlocutory application? That effectively, you seem to be saying we have to accept on this interlocutory application that this claim will inevitably succeed.
No, I have to show your lordships that as a question of law, there's a strong prima facie case of iniquity in the legal advice. I don't have to show inevitability. Strong prima facie case is the test.
You appear to be almost saying just now there's no possibility of the company succeeding.
On that particular limb, proportionate means of achieving a legitimate aim, I say there really can't be any dispute. If part of the reason for Mr. Curless's selection for redundancy was his disability-related performance, I do say that realistically the company has no chance of objectively justifying that. And that is because they have put all of their eggs in the redundancy basket. You've seen the pleadings. They plead that the dismissal was exclusively because of redundancy. They haven't tried to justify a poor performance dismissal.
Very well. I'm very conscious that we're keen to get onto the email, and we're, I'm not trying to stop you because obviously what these is. I'm just going to introduce them de bene esse.
Yes.
But at the end of the day, we need to understand what the critical email means.
Yes. Well, and this, I say, is highly relevant to the critical email because it shows that for some time the company had been considering a quote-unquote reorganisation route in order to get rid of the claimant. And it shows that that plan was motivated by its unhappiness with his performance.
Essentially, I think your submission comes to this, doesn't it? That Shell could not justify dismissing Mr. Curless on performance grounds. Therefore, there is a strong prima facie case, either that the redundancy exercise as a whole was a sham, or that Mr. Curless was selected for redundancy because of his disability, and that selection cannot be justified.
I'm very grateful. My Lord has finished a point which I meant to make earlier in response to a question from the Master of the Rolls, and that is that a company that wants to get rid of an employee for ulterior motives in the context of reorganisation can do so in two ways. The first I mentioned is to choose his role for redundancy, and the second is, even if there's a legitimate choice of which roles are going to be made redundant, once you've got a pool of employees who are therefore at risk of redundancy, selecting that individual, as your lordship posits, for illegitimate reasons instead of the other individuals in the pool.
Well, all these will be issues at the trial and the tribunal. I can only say it doesn't seem to me that the outcome is obvious. That there can only be one result.
Well, so far I've made a submission on the outcome of one of the issues, which is proportionate means of achieving a legitimate aim, and I do submit that in circumstances where the company has said that the exclusive reason for dismissal was redundancy, not performance, the outcome of that particular issue would be obvious. The other issues I'll come to on the interpretation of the email, if I may, the motives for wanting to dismiss Mr. Curless. So finally, in the chain of fresh evidence emails, we have page 3. And the same points apply here too, I say, about this not being a lawyer-client communication which seeks or gives legal advice. Again, Pam, the line manager, in the body of the email addresses it exclusively to Eleanor, the HR advisor. There's no request in the email for legal advice. And it's the first paragraph which is relevant. Could your lordships reread that, please?
Do you know offhand when Shell took over the case?
I think it was in early 2016.
2016. So
Yes.
That's after this email.
It is.
And we are told that it was that which triggered the company reorganisation.
Yes.
So there is a pretty significant intervening event between these emails and the one that we are focusing on.
There is, but what these emails show is a consistent course of looking for a way to use a reorganisation to get rid of the claimant. You've seen the reference in one of these emails already to reorganisation route being considered again. So it clearly had been considered already before this point in time.
Yes, thank you.
And the point on which I should just say there's a reference there in regards to a PIP, a performance improvement plan. I would like to have a discussion with Mike when he returns from leave so that I can gauge what he may be thinking. It's a matter of common ground recorded in the company's first ET3 for your notice, paragraph 47 at page 133 of the bundle, that he was never put on a formal performance improvement plan. So the company never went down the route of trying to dismiss him fairly for performance. More importantly, the last sentence, indeed, with the current economic issues the company is facing, a restructuring may again need to be considered. And that, I say, is the line manager picking up on the HR advisor's suggestion of using a reorganisation route in order to end the claimant's employment. So, your lordships will be pleased to hear that's all of the emails, and against that background I can deal...
Is the question whether he was in fact put on the PIP, or whether there was a genuine intention to have a discussion about a PIP when he returned? I mean, are you saying that we are to assume on this application that the reference to having a discussion with Mike when he returns from leave with regard to a PIP is just not genuine?
It's common ground that there was discussion about a possible performance improvement plan. Right. But that's a formal mechanism which an employer uses to fairly manage and ultimately dismiss an underperforming employee, and that formal mechanism was never initiated.
Right. Thank you.
So having dealt in a bit of detail with the emails, I can address the Ladd & Marshall factors relatively briefly. I do have a copy of the relevant part of the White Book which I can hand up. Your lordships are probably very familiar with the Ladd & Marshall factors already.
Just give us the reference in the White Book. You don't need to have a copy.
There's only really factor 2, isn't it, that you need to address? It's accepted that you couldn't have disclosed this, got this information earlier. It's not suggested that the emails aren't credible. So the question is, are they likely to have an important bearing on the outcome of the appeal?
That's absolutely right. Yeah. The relevant pages of the current edition of the White Book are 1818 to 1823.
Thank you. Right.
And on the second limb of Ladd & Marshall, I say that the emails demonstrate that as at December 2014 and January 2015, the company was looking for ways to terminate the claimant's employment, that it recognised that it would be difficult to do so by reason of his performance, and that it therefore shied away from going down that route towards his dismissal, and that it was also considering the possibility of terminating his employment under the guise of a reorganisation or restructuring. And I say that those matters are highly material to the correct interpretation of the April 2016 email, in particular whether that email records advice on how to use a reorganisation or redundancies as a tool to effect Mr. Curless's dismissal for other motives, with those motives pre-existing the purported intervening event of the British Gas acquisition. And so they bear on what I say is what I think is common ground as the principal issue in the appeal, which is the interpretation of the email. I say the email is the coming to fruition of a plan which had long been in the gestation.
Yes. Yes, thank you.
I should just respond briefly to one point made by Mr. Tankey, and that was that it's now being alleged that the conspiracy to dismiss Mr. Curless was wider than previously alleged. I want to make clear that before the Employment Tribunal, we did place reliance on emails which I'm going to take you to shortly from February 2014, where there was similar discussion about using a restructure in order to end the claimant's employment. So we have alleged all along that you can see a consistent course of the company looking for ways to use a reorganisation to get rid of him, and this isn't a new allegation. So my lords, moving to the second part of my submissions, which is the factual background against which the email falls to be construed, just to set the context for that, I want to remind your lordships of what I was saying about the ways in which a company can use a reorganisation in order to dismiss someone for unlawful reasons. And it's important to bear in mind the fundamental issue in this case is as follows. The company contends that the claimant was dismissed solely because of his redundancy. It doesn't contend that he was dismissed because of capability on grounds of his performance.
Well, that's right, of course, but aren't they saying there was a redundancy situation following the reorganisation, the need for lawyers or lawyers of a particular kind had diminished. Then the question is, why did they select Mr. Curless for redundancy? As opposed to
That's one of the two questions. The first question is, why did they select his role as one which was to be made redundant? And second, why did they select him rather than one of his two peers, Ms. Reeder and Ms. Hasler?
Yeah.
That's right. By contrast, the claimant's case is that he was dismissed because of his protected acts and or because of his performance problems which resulted from his disability. And I just remind the court of a well-established principle of employment law, that Mr. Curless was the victim of unlawful victimisation. His protected acts had a significant, that is, a more than trivial influence on the decision to dismiss him. The protected acts or disability-related underperformance need not be the only or even the main reason for his dismissal in order for unlawful victimisation or discrimination to be made out. So it's very well established in the employment cases, if an employer has mixed reasons for dismissing someone, let's say, both the fact that redundancies are needed and the fact that this individual has done protected acts, they will thereby act unlawfully. And I mention that point partly in response to your Lordship's question yesterday. In employment law, are you not allowed to choose one person for redundancy because he's difficult? If the reason why someone is perceived as difficult is because he's complained of discrimination, done protected acts in the lingo, then the answer is no. You're not allowed to dismiss him for redundancy because he's difficult. So against the background of the key issue in the case, I turn to what I say are the key aspects of the factual background.
Does that mean if you have a post you want to make redundant for genuine reorganisation reasons, and there are 3 people carrying out the tasks of that post, 2 of whom are performing well, and the other one isn't, and there are some matters which are for which he's protected, which feed into his unsatisfactory performance. That you have to, you either can't make anybody redundant, or you have to make one of the other people redundant.
No, not necessarily. Everything depends on the employer's quote-unquote reason why. Why did the employer choose individual 1?
Well, I've just given you that. I know that, but I've just given you that rather stark example, because we're told the other 2 here were performing well. It doesn't have to be this case. I'm just trying to understand the general principle. You seem to be making putting down an absolute statement. I don't know if it's correct or not. I'm just asking you that where there's a protected act which has had which is more than a trivial, had more than trivial implications or consequences.
Influence on the decision to dismiss.
Influence on the decision. Then you cannot dismiss him. You cannot select him for redundancy for that purpose. Is that right?
That's right. If the selection...
I'm just trying to understand that in the context of a case where that is true. It is more than trivial, but it's not the only reason. And you have 2 other people who are performing well. And the point I'm putting to you is, if that is an absolute statement you're making, that must follow. You either can't make anybody redundant, or it has to be one of the people who are performing well.
No, well, there are 2 different things we're talking about here. On the one hand, there's protected acts, and on the other hand, there's disability-related poor performance. When it comes to protected acts, no part of the employer's reason for choosing...
The protected act here being making a claim.
Making a claim and an internal grievance, both complaining of discrimination.
Yes.
No part of the employer's reasons for choosing individual 1 for dismissal can lawfully be the fact that he's done protected acts.
Right.
That's the law.
Anyway, the issue whether or not it is more than trivial is a matter to be debated, isn't it, at the trial?
It is, but I mean, again, I come back to the rubric strong prima facie case, and I say...
No, but your case is even before him. I mean, this is where your case is, you may be right about this at the end of the day. Your case, as I understand it, is right from, I think you're saying, February 2014. The company was set on a course of getting rid of him before he'd made any of these complaints.
Yes, and we say that his dismissal was unlawful for 2 reasons. 1, because it was because of disability-related underperformance.
Yes.
And 2, because it was because of the subsequent protected acts.
Could I ask, just looking at the ET3 at tab 13, just wonder how much of this is in dispute. I'm looking at page 150 in the bundle, which is where Shell explained their case about what happened. They say that there were three contract and procurement lawyers at JG2 level. They decided to reduce that to two. The three employees carrying out that role were Miss Reader, Miss Hasler and Mr. Curless. Those three were told they could apply for the remaining two contract and procurement roles, as well as any other vacancies. Mr. Curless didn't apply for his current role as contract and procurement lawyer. The other two did, and they were successful, but he applied for different roles, for which he wasn't successful. So that's agreed, is it? He didn't reapply to carry on doing the job he'd been doing.
That's agreed. I'm taking the implication of your lordship's question. That choice by the claimant post-dated the April 2016 email. I say that the design which is disclosed by that email is a design to use a redundancy to dismiss him for other reasons. And it just so happened that after that he did decide not to apply for that particular role. But that, I say, doesn't have a bearing on the correct interpretation of the email. And he says that he didn't apply for that role and apply for the others instead, because by that point he had been invited, the court would have seen this already, he had been invited to opt for SBS, voluntary redundancy, and his two colleagues had not. So he took it that the writing was on the wall and there was really no point applying for those roles, for what it's worth. So there are two documents, both of which were shown to the Employment Tribunal, which show that after the claimant started to suffer from sleep apnea and diabetes, and after his performance started to decline, the company formed a desire to end his employment, and more importantly, started to consider using a redundancy process in order to do so. Could your lordships open the supplementary bundle, please?
We're still on the question of admissibility of the emails, are we?
No. This is now evidence that was in front of the tribunal. We're on the facts.
Right.
Factual background.
Factual background.
Right. Supplementary bundle, yes.
Page 48.
Yes.
So this is a two-page email chain dating from February 2014, and I really want to pick it up at the top of page 49. Just for context, the emails preceding that emails which are discussing the claimant's IDP. I think that's his individual development plan. So the context is discussions about his performance again. And at the top of the page, we got the email from Kim Lennon of HR to Pamela Nelson, the line manager. Pam, just curious, did Mike update his IDP in time? I'm due to see Ahmed, that's another HR, I think a senior HR person, tomorrow. So I'll test different options with him. Feasibility of medical release, and then suggest we have a call to discuss next steps on Mike, okay? And then on page 48, at the bottom of the page, we have the line manager's reply to the HR advisor. First sentence is about the IDP, development plan, and then the second sentence, would greatly appreciate some steer regarding full or partial medical release. So in other words, we see here the line manager expressing an interest in the HR manager's suggestion of terminating the claimant's employment. And then the second document is 2 pages on page 50. Could I ask your lordships to read that email chain, please? It starts.
Are all these matters that were taken into account by Mrs. Justice Slade, are they not in? Are these new matters now?
No, these were all raised both in front of the Employment Tribunal and in front of the EAT.
Right, but does she refer to any of these matters?
She doesn't know.
So page 50, what would you like us to read?
If you could read that single page, please, and the chain starts at the bottom of the page.
Yes.
It's an email in the middle of the page, again from Kim Lennon, the HR advisor, to Pam Nelson, the line manager. The key sentence is the last one. If you foresee a strong business case to restructure, if the balance of CPIT work is diminishing, this is something to discuss again. And then above that, thanks Kim. The only way I could see us restructuring would be if we could get Claire's role, that's Claire Reader, one of the 2 peers, to be full-time. Since we're not getting 100% of Mike, I think one full-time person could cover both roles. Sounds like there was some discussion about shifting Claire around during the meeting with the DSLT, not sure what that is. If any of that could work out such that we swapped for a full-time person, that could work. Can you keep your eyes open for that? So I say that we have here the company looking for an opportunity, such as a reorganisation, to get rid of the claimant. And specific discussion about Ms. Reader, one of the peers, and the claimant with the same role. But no discussion about Ms. Reader and the claimant being put into a redundancy pool together and fairly and neutrally selected for redundancy. I say clear evidence of predetermination.
I may be going backwards, but I notice at the bottom of page 50, Pam Nelson is described as the Associate General Counsel. You told us that she was an HR person. Why is she described as counsel?
No, Pam Nelson is the line manager.
Oh,
So the claimant himself was a lawyer, his line manager was a lawyer.
I see.
Mr. Halliday, as in many cases of this kind, you have an employee who, rightly or wrongly, is regarded as an underperformer. Management discuss what to do about it. Then, a year or 2 later, there's a redundancy round because of a reorganisation. He's selected for redundancy. The obvious issue is, was the selection genuine, or was it part of did it result from a long-standing desire on the part of management to get rid of him? Seems to me a shame that the last 2 years have been spent on the email of the 29th of April 2016 and the legal advice, because the case such as it is there anyway, and it'll be for the tribunal to decide whether your client was genuinely selected for redundancy, and as you pointed out, whether the motives for doing so were mixed, and one of the reasons was the fact that he'd done a protected act.
There may well be some truth in your lordship's observation. When the claim was pleaded out, the key piece of evidence on which reliance was placed was the email, which had been sent anonymously in the post. The focus was squarely on the email at that point in time. There is other evidence in support of Mr. Curless's case, that's absolutely right. I mean, I do say that the email, the April 2016 email, lends considerable further weight to his case, though, both because of what it says and because of the identity of those referred to in the email. David Brinley is the indirect line manager who would have had a key role in the decision making in this case, and we don't have other documents in the bundle linking him to the decisions that were taken. So I take your Lordship's point about the proportionality of this issue, but the email is nonetheless an important piece of evidence. So I'd like to turn then to the third part of my submissions, which is ground one, the correct interpretation of the email.
Yes.
Now, in the light of yesterday's discussion, I should just briefly state my position on the question of whether any special deference is due to the employment judge on the interpretation of the email.
Yes.
And I say that it's not, because the interpretation of a document is a question of law. See Air Tours at paragraph 40. So the question is, on a correct interpretation, the question before this court is, on a correct interpretation, does the email disclose a strong prima facie case that this was advice in furtherance of iniquity? And because that is a question of law, I say that your Lordships can approach the question afresh with no special requirement for deference to the Employment Tribunal required.
Thank you.
Or for that matter to the EAT.
Well, in a sense, even less so. Well, deference isn't the issue, I suppose, but as my Lord Justice Bean pointed out yesterday, when employment cases reach the Court of Appeal, the real issue is whether the Employment Tribunal got it wrong. So even if I'm wrong about the interpretation of the email being a question of law, the focus then turns not to the EAT's judgment so much as it does to the ET's judgment. On the meaning of the email, I want to deal with this in two parts. First of all, the interpretation of the email on a strict textual analysis, looking at the email on its face in isolation. And we have it in the supplementary bundle at page 77.
Yes.
And I have three broad submissions about the text of the email. My first submission is that the text shows that the company had already decided that it wanted to terminate the claimant's employment by this stage. And I say that there is no other explanation for describing a redundancy process as the company's best opportunity for dealing with the claimant.
So it's already decided
To dismiss him, that it
dismiss
wanted
him.
to dismiss him.
Right. And, sorry, carry on, and the...
There's no other explanation for describing a redundancy process as the company's best opportunity for dealing with the claimant.
That's not what it says with respect. This, in the first line of the second paragraph, is the twin track of voluntary settlements and possible redundancies, compulsory redundancies.
Yes, sorry, I was using redundancies as a shorthand for voluntary and compulsory redundancies.
Well, I mean, if Mr. Curless had been persuaded to go for selective voluntary settlements, there wouldn't be anything wrong with that, would there?
No, he would have consented.
Yeah.
It wouldn't have been unfavourable treatment. an employer can only refer to a redundancy process as an opportunity in relation to someone it wants to dismiss. And I say that the company's desire to dismiss the claimant is confirmed by the words, otherwise we risk impasse and proceedings with ongoing employment. So I say that says that avoiding the claimant's ongoing employment is desirable. Ms. Ward is advising a course of action, commending a redundancy route as a way of avoiding the claimant's ongoing employment. And I also ask rhetorically, how was Ms. Ward to know at this point in time, before the redundancy selection process had even begun, supposedly before any decisions had been taken about who would and who would not find a role in the new structure, that the redundancy process was liable to avoid Mr. Curless's ongoing employment? And I say that this is strong prima facie evidence of predetermination, of a decision that the claimant, rather than his colleagues, was to lose his job. Now, if your lordships accept the proposition that the email contains strong prima facie evidence of a pre-existing desire to end the claimant's employment, even before the redundancy process began, then that inevitably raises the question, why did the company want to terminate the claimant's employment? And this brings me to my second submission.
Right, so there's a lot of language there. Does it come to, your first point is that particularly the last sentence in the second paragraph shows that there was a predetermination that he rather than his colleagues would be selected for redundancy, and the rest of the paragraph makes clear that the reason for wanting redundancy is because they want to get rid of him. Is that what it comes to?
Yes, it comes to that they wanted to get rid of him is the first submission.
Yeah. Right. Yes.
Now, if your lordships accept the first submission that this is strong prima facie evidence that they already, before the redundancy process began, wanted to get rid of him, inevitably that raises the question, why did they want to get rid of him? And that's my second submission on the interpretation of the email, is that it also discloses a strong prima facie case of at least part of the reason why the company wanted to end the claimant's employment, namely, I say, his ET claim for discrimination. And I submit that that is the only possible meaning of the reference to proceedings towards the end of the email.
His existing ET claim.
Yes, I say the existing ET claim. Must be what's referred to as a matter of logic, really, because sacking him wouldn't avoid future proceedings. And the email says, otherwise we risk impasse and proceedings of ongoing employment with no resolution. So otherwise, that is, if we do not consider the claimant for redundancy, we risk impasse and proceedings with ongoing employment. So the meaning of that is clear, I say. We don't want proceedings with ongoing employment. In other words, we don't want to continue to employ someone who is prosecuting proceedings against us.
I thought we'd accepted those proceedings would survive, whatever.
Yes,
The
I think
existing proceedings would. I thought that was accepted, that the existing proceedings would not fall just because he was made redundant.
no, that's right. Reading that sentence, otherwise we risk impasse, I think the next 4 words need to be read together.
Your point
Makes
is that
sense
they
of
don't
it.
want the combination of proceedings
Precisely.
and ongoing employment.
I'm grateful to the Lordship for expressing it better than I did. Yeah. So, I mean, sacking him wouldn't, as my Lord the Master of Rolls points out, dispose of the current proceedings. So the only sensible way to read that sentence is to read proceedings with ongoing employment as a combination.
No, but this goes to the question about whether or not the protected acts were more than a trivial reason for what took place.
Yes.
But I'm having some difficulty with that because the proceedings were going to carry on come what may.
What this says the employer didn't want was to have in its employment someone who had proceedings against them. It didn't want proceedings with ongoing employment.
So in other words, it's one thing to have proceedings brought by an ex-employee, it's another thing to have one proceedings carrying on being brought by a current employee.
That's right. It would be preferable to have proceedings with an ex-employee to having proceedings with an ongoing employment.
Well, it means, doesn't it, that if it, putting it crudely, if he's sacked, we then have 2 lots of claims, but at least he's off the books.
Yes.
On the other hand, if he's kept on, we have the impasse of keeping somebody we don't really want. And by the way, the first employment tribunal claim will carry on anyway.
Yes, but we don't want it carrying on with someone we employ. Much better to have it carrying on with someone who's no longer in our employment. And I pray in aid here the test for victimisation, which I mentioned to your lordships before. Victimisation will be made out if the protected acts had a more than trivial influence on the decision to dismiss. You have the point.
Well, Mr. Halliday, what legal advice do you say Miss Ward was legitimately entitled to get from Miss Gill as of the 29th of April 2016?
I think this is recording advice, whether it's legitimate legal advice is the question. It was recording advice from Ms. Ward to David Brinley. So this is a record of a conversation between Ward and Brinley.
All right. Well, what
So-
legal advice was Mr. Brinley entitled to get from Lewis Silky?
Advice which was not in furtherance of, for the purpose of effecting, iniquity. And that could include, in this sort of context, multiple things. If we do X, would that be unlawful? What would a fair redundancy process look like?
Sorry, if we were to do X, would it be lawful? That's not within the exception.
That's not in furtherance of iniquity. And that there's authority on the distinction. It goes all the way back to O'Rourke
Yeah.
about the difference between assistance in commission of iniquity and taking advice on your legal rights and obligation. It's the former which is illegitimate, caught by the iniquity principle, and the latter is fine.
Yeah. So I mean, when the email records that if a redundancy process is done with appropriate circumstances and in the right circumstances, it might get rid of the claimant. Would one not then expect somebody to say, well, what are they? What are those safeguards and in what circumstances?
Advice on the safeguards would be fine.
Yeah.
This is how you do it lawfully and fairly.
Yeah. So the preliminary indication that safeguards and what the right circumstances are. Why is that wrong? If the next step in seeking the advice is to say, well, what are those safeguards and what are the right circumstances?
Read in itself, there's nothing objectionable about saying we need the right safeguards. If you read this email as a whole, I say it means you, Mr. Brindley, want to get rid of the claimant because of his protected acts. Here's how you can do it. Here's a redundancy or a reorganisation that you can use to effect your, I say, iniquitous plan of victimising him.
Well,
And just taking up that passage to which your lordship referred me, that is saying, even though the real reason we want to get rid of him is protected acts, if we play it right, we can put it into the context of the reorganisation and therefore defend a claim against him.
well, is the email going any further than saying this is worth considering? That's what it says in the
No, I accept that.
last sentence.
I accept it says it's worth
It's
considering.
not saying this is what you can do or this is what you should do. It's saying this is something to consider. And maybe on further consideration, somebody will say, well, it doesn't really work because your real reason for wanting to get rid of Mr. Curless is nothing to do with redundancy.
It does talk about considering that route, but I also say that it commends it. And we get that from the language best opportunity and otherwise. Now, I'm still on my second submission on what the email tells us about the reason why the company wanted to dismiss the claimant. And I just want to depart from the strict textual analysis briefly before I come back to it. I mean, I say that if you accept that the email shows the company wanted to get rid of him, that inevitably raises the question, why? And from the wider context, I derive the proposition that the only other plausible, remotely plausible reason why they wanted to get rid of him was his underperformance. And of course we say that if that was part of the reason they wanted to get rid of him, that's the foundation for a claim under Section 15 of the Equality Act. My third submission on the text of the email.
I'm sorry, I'm
Yes.
still struggling a bit with. There are two bases on which you attack the legitimacy of the redundancy, as I understand it. One, and these are matters to be determined ultimately at the trial. One is you say that the making by him of an internal complaint by bringing the employment tribunal proceedings were protected acts, and if they played more than a trivial influence in what took place,
The
his
decision,
dismissal,
yeah.
then that was illegitimate. The second is that if they wanted to dismiss him, one of the grounds for selecting him for redundancy was because of his underperformance. That underperformance was related to his disability. The fact they can't rely upon that because they ought to have provided him with the facilities to meet the consequence of that disability, which they failed to do. And therefore they can't rely upon that underperformance as such. That's in broad terms.
I gratefully adopt all of that except for just the very last part, which is the legal test for whether dismissal because of a disability-related underperformance is lawful is whether it was a proportionate means of achieving legitimate aim.
Right.
And there are going to be various factual strands to that, including what
there's
you're
a proportionality element there.
Yes.
So, I mean, for example, if it would require too much money or whatever it might be, a disproportionate amount of money or reorganisation to accommodate that, that might be a justification. It doesn't matter. But there are those two different categories, I understand.
Absolutely.
Now, I understand, I can understand the logical position in relation to the second point, where you say, well, right back from February 2014, there's a consistent pattern of trying to see, of saying there's underperformance and it's very unsatisfactory, and you would add, and we'd like to get rid of him if we possibly can. That's what you would say. I understand that, and I understand on the basis of that, your submissions, or what you say, is the interpretation of this email. Where I'm still somewhat at a kind of a loose end is in relation to the point about the relevance of the protected acts. Because even if you're right about the interpretation of the final sentence of the second paragraph, the proceedings would continue. And therefore, I don't really see how. Or are you saying they didn't realise that? Are you saying we must assume that they didn't realise the proceedings would still continue? That the assumption of the email is that the proceedings would somehow come to an end?
No, my lord. My submission on that sentence is that essentially you need to put a pair of brackets.
So I understand what you say, but I don't understand. How does that go? That could go, I certainly understand, to this point about underperformance. I understand the whole email is consistent with what you're saying about that. What I don't understand at the moment is why you say the email shows anything with regard to making him redundant because of the proceedings, which would continue in any event. That's what I don't understand.
Because I say what it discloses is we don't want an employee who's got proceedings against us. Why don't you want him? Because he's got proceedings against us.
We're to read into this, it's this last sentence, we're to read into the last sentence that we don't want him merely because he's a bad performer. We don't want him because he has started proceedings. You want to get that out of the last sentence.
I do. I mean, I've relied principally on proceedings with ongoing employment, but on pass and no obvious resolution, I say, are also liable to be read as references to the dispute with his employer. You'll bear in mind that at this point in the chronology, he's also got an unresolved internal grievance against the company. And that, I suggest, is a strong prima facie reading of on pass and no obvious resolution.
Right, thank you for explaining that. Yes.
My third submission on the text of the email is that it also discloses advice on how to cover up the company's true intentions. Its real intentions being to dismiss Mr. Curless because of his protected acts and performance, and to cover that up with the cloak of a wider redundancy exercise. And I say that that's a strong prima facie interpretation of the words, there is at least a wider reorganisation that we could put this into the context of.
That's in the context of an argument that the selection was either unfair or discriminatory.
That's right. Turning away from the strict textual interpretation, I submit that my interpretation is supported by the factual context in two respects. First, the fact that the company had already been discussing how to utilise a restructure in order to end Mr. Curless's employment for some time, looking for an opportunity to do so. And secondly, the old Bank of England conversation. I say both of those are contexts against which the email falls to be construed. And on the first point, I've taken your lordships to the evidence already this morning. I just remind you of, first of all, the email exchange between Ms. Nelson and Ms. Lennon at page 50 of the supplementary bundle from February 2014. And secondly, the fresh evidence emails. And I say that what we see in the email on page 77 is the coming to fruition, the execution of the very plan which was being discussed in those earlier emails. As to the conversation in the old Bank of England, at the hearing before the Employment Tribunal, when the company was disputing that this conversation had ever taken place, the company's counsel rightly described it, if it had occurred, as a killer piece of evidence. You would have read that in the Employment Tribunal's judgment. It's paragraphs 31 and 79, if you'll note. And the company's counsel also acknowledged, and this is recorded at paragraph 82 of the judgment, that the old Bank of England conversation referred to the claimant's dismissal for redundancy as something which has all been acted upon and has been decided as a fait accompli.
Sorry, did you say that the company's representative accepted it was a killer piece of evidence?
If true.
Okay, well, para 31 of the ET says the claimant accepted that it was a killer piece of evidence. And 39, which was the other paragraph you referred to, doesn't seem to say anything about it. So where's the bit in the ET that you're relying on?
So I have read, I was there, so I've read slightly between the lines of the transcript of the judgment. The claimant accepted in cross-examination, when he overheard the conversation, at the killer piece of evidence. The question was put.
I see, you mean,
the question was put to him.
Shell's counsel put to him.
That's what I mean. That's what I mean. Yeah. I should have made that.
And so we are because of the question was put in that way to the witness. You say that is a formal admission by the company that was so.
I don't say that. It's something of a jury point, and
I thought so. I mean, what counsel plainly meant and should have said was, you regarded it as a killer piece of evidence, and therefore why did you not immediately act on it? The whole point of the question was, why didn't Mr. Curless immediately make a big fuss about it?
I take the point, and I don't.
I mean,
I don't press it at all. Yeah.
Well, be careful what you wish for, because you may be in that position one day.
I think just to give it context, Miss Romney was putting to Mr. Curless in this particular context why he hadn't gone to, precisely as your lordship put it, why he hadn't
context,
why he hadn't reported this piece of.
Yes.
Yeah, I don't place any reliance on that point. I'm grateful to be corrected genuinely. Sometimes one gets carried away. We can see the account of what exactly was said in the old Bank of England in the tribunal's judgment at paragraphs
26 and 27,
April.
isn't it? Because that's the claimant's account, which the ET says that they accept, or he accepts.
Exactly, yeah.
Yeah.
Exactly. So
It's really 27.
It's 27. The findings incorporate by reference effectively the claimant's account given at 27. And the key sentence is that I'm picking it up in line 4. The speaker, she said that, however, his days were numbered. As there's a good opportunity to manage them out by severance or redundancy. And I rely on those words, days were numbered, because bear in mind that when the conversation in the old Bank of England took place, the redundancy exercise had not even been announced. Not even been individual consultation in the redundancy process began in June 2016. The conversation took place in May 2016. So at this point in time, no selection process about whose days were numbered was supposed to have taken place. So I say that this is a description not of a fair redundancy selection exercise, but a predetermined decision to end the claimant's employment. And I say that the conversation in the old Bank of England casts further light on the meaning of the email, and that it confirms that the company had already decided by this stage that it wanted to dismiss the claimant rather than simply put him through a fair and neutral redundancy selection process alongside his peers. Mrs. Justice Slade declined to take account of the Old Bank of England in construing the email on the basis that it was unauthorised and that there was no contemporaneous note of what was said.
Well, can we just see what's going on here?
Yeah.
We've got a woman who's speaking. She's one of a group. There's nothing to identify her with Lewis Silkin. Mr. Curless notes that one of the men was carrying a Lewis Silkin notepad. There's nothing to identify the woman with Lewis Silkin. There's nothing to identify her as a Shell employee, is there?
No.
One of the women mentioned dealing with a complaint by a senior lawyer at Shell, and then the woman, so that presumably is the same woman. But we don't know who she is.
No. What I rely on is her knowledge of what was going on. I say that she wouldn't have been able to say any of this unless she were an insider with good information about what was happening.
You say she was an insider?
Yes. In order for her to state and therefore know these details, she must have been privy to what was going on.
Now, you told us that this was conversation was before the individual discussions about the redundancy.
Yes, I'm just hesitating slightly on the
Because I want to ask you whether that's in evidence.
Yes, it's core bundle, page 150.
Yes.
Paragraph 32.
So yeah, early June is these discussions.
And in fairness, I should point out paragraph 29, collective consultation began on the 23rd of May 2016, which would have been 4 days after the claimant's best guess about when the conversation took place, but he's not quite sure.
So it's
Consultations on the 19th of May, roundabout. That's page 102. And collective consultation begins on the 23rd.
And then individuals about
June.
the same time.
Individuals a little later in June.
Go around the same time. when you say well, the next sentence is in concerns with individuals affected by individuals affected individual affected employees is carried out around the same time, but you've got a later date.
Where's your lordship reading from?
Paragraph 29, second sentence.
Yes, there's a more detailed definition of the date at paragraph 32, certainly in relation to the key individuals.
Early June.
Yeah. Should say more precise.
Yes.
So, I mean, as to the Mr. Justice Slade's point that this was an unauthorised conversation, which I mean, absolutely must have been, I say that that doesn't detract from the speaker's knowledge about what was going on.
Are you relying on this conversation to inform the interpretation of the email, or are you relying on it independently? I suppose that the email means what Mr. Banky says it means, and what the EAT found it meant. Do you rely on this pub conversation independently? Or is it simply an aid to interpretation?
It's simply an aid to interpretation.
Simply an aid to interpretation. So a conversation on the 19th of May is an aid to interpretation of an email of the 29th of April.
Yes.
That's a rather unorthodox approach to interpretation of a document. It's simply a question of law.
I mean, I say that the speaker in the Bank of England, Old Bank of England, was in a, to use an unfortunate term, privileged position when it came to interpreting the email. As an insider who knew, it would appear, knew the ins and outs of what was going on, she was in a better position to read between the lines of the advice given by Ms. Ward than outsiders.
But there's no evidence, is there, that this unnamed woman saw the email?
No, it's a matter of inference from what she expressed in the Old Bank of England, that she was aware of the legal advice, or the advice that Ms. Ward had provided to Mr. Brimley.
Difficulty, a possible difficulty, is that the email is saying this is something to consider. There needs to be safeguards and there need to be the right circumstances and so on. So that's the advice. And if the client says to somebody else, well, this is what we're going to do, how does that taint the advice?
That is a possibility. If that's what happens, then the conversation in the Old Bank of England doesn't cast light on the email. If the speaker is repeating something other than the advice in the email, then it's not an aid to interpretation of the email. Again, I fall back on the strong prima facie case strong prima facie case test. I say that the likelihood is that this is someone elucidating what was said in the email. Just one other submission I should make on the interpretation of the email. As my Lord Justice Bean pointed out yesterday, traditionally the view is taken in this court that it's the correctness of an employment tribunal's decision that's under appeal here. If you agree with me that the interpretation of the email is a question of law, I don't need to show that the employment tribunal's interpretation was perverse. But in case you don't agree with me on that point, I should just briefly say why there are errors in the employment tribunal's interpretation of the email.
Sorry. Well, I think you can assume we're going to proceed on the basis that it's a question of law. You don't have to give
I'll
any
wait for it. I don't need to deal with
It's
it.
not a fact-finding exercise.
I don't need to deal with it. So since we're not dealing with the iniquity principle in the context of the Old Bank of England, my fourth and final part of my submissions is to address your lordships on the question of law, whether a matter of law on the correct interpretation of the email, the iniquity principle applies here. And I just want to address two short points. The first is whether dishonesty is a necessary ingredient
Yes.
in order for the iniquity principle to bite. And secondly, although I do say it's a somewhat sterile issue, whether a strong prima facie or a very strong prima facie case is required.
I thought it was common ground that if your interpretation of the email is right, then the exception does apply, and if the ET's interpretation is right, then it doesn't.
That is common ground. I've reflected overnight on whether there's any intermediate possibility, and I think there is. It might be unlikely, but I'll try to express it. If you're entirely with me on the interpretation of the email that it included a cloak, which we say was dishonesty, then dishonesty doesn't matter. But it might matter if you're only partially with me on the interpretation of the email. If your lordships accept that it was advice given or received for the purpose of victimising or discriminating against the claimant, but do not accept that there was any element of dishonesty in it, then the legal issue on dishonesty would matter in those circumstances.
Well, I don't understand that. So you're saying it was bad advice but not dishonest, is that what you're saying?
No, it was advice on how to victimise him. You want to dismiss him because of it, or discriminate against him. You want to dismiss him because of his protected acts. This is how you can do it. But there's nothing
That's not what's being contended for here. I mean,
it is. That has always been part of
I've understood. I've always understood Mr. Thankey to be saying this was a perfectly legitimate advice to be given. It was subject to considerations and subject to the appropriate circumstances, and it was therefore all subject to appropriate. And as my Lord has said, on that footing, it was a perfectly standard advice that was given and would meet the response, well, what are the appropriate circumstances? So I don't understand anybody to be contending about this intermediate course.
Well, the intermediate course is a possibility if you partially accept my interpretation but don't accept the whole of it. If you accept that this was advice on how to victimise but not dishonest, then you'll be accepting part of my interpretation but not the whole. Your Lordship raised the point about the respondent's notice yesterday, and I do think the point is put in the respondent's notice. I can take your Lordship to it.
What do I...
So can I just clarify my mind on this? So an employer goes to a lawyer and says, I have a disabled employee who is not performing properly because of his disability. What should I do? And the lawyer says, sack him. Clear advice to discriminate on the ground of disability, you say that falls within the exception to legal advice privilege?
I do, yes.
Really?
I say it's entirely contrary. It's iniquitous conduct because it's conduct which is entirely contrary to public policy.
That's a very broad submission. It's going to apply in practically every case where a selection for redundancy is said to be discriminatory.
It would only apply where the lawyer gives advice in furtherance of the discrimination. Wouldn't apply where the lawyer says these are your rights and wrongs. If you do X, it will be lawful. If you do Y, it will be unlawful. But if the employer says this is how you can discriminate, then I submit it. I should refine the submission slightly.
Can we just see what you put in your response notice? I'd just like to see exactly how you put it there.
The relevant paragraph, it's page 39 of the core bundle. Paragraph 1, subparagraph 2, subparagraph A. The email disclosed not only advice on how to cloak as redundancy the real reason for dismissing the claimant, but also advice on how to victimise and discriminate against the claimant.
Knowing it was wrong or not knowing it was wrong? This is where I'm slightly confused at the moment. I mean, you can give bad advice without appreciating that it's unlawful.
Yep.
So I'm just trying to understand the context for this. This alternative submission is what? That the advice that was given was in the knowledge that it was discriminatory?
The lawyer,
and with intention discriminatory.
the cases say that the lawyer's state of mind doesn't matter.
Right.
If the lawyer's advice is being used as a tool in furtherance of iniquity, then it doesn't matter whether the lawyer knows or doesn't know that that's what's happening.
We're talking about the commission of a tort.
Yes, it is a tort.
So if I go to my solicitor and I say there's a piece of land next to my garden which I would like to incorporate into my garden, he says, well, if you take possession of it, you get squatters' rights after 12 years. Does that fall within the exception?
No, I fully accept, decided in Crescent Farms, never doubted, that not all civil wrongs constitute iniquity. I said before I wanted to refine somewhat my answer to your Lordship's question about whether the solicitor saying sack a disabled employee would be iniquitous. And I do say that whether something is iniquitous is regrettably a matter of fact and degree. And it's really the point here is addressed in my skeleton argument.
I'm just trying to see, because we're spending a lot of time now before you actually get to the hills themselves, we're in the foothills all the time. Would it be easy if you just make your submissions by reference to the authorities you want to refer to?
Yes. Yeah.
Why don't we go straight to the authorities? Then you can develop the submission in the course of referring us to the authorities, so we can actually understand the context.
Yeah.
Can I just put one more question? Can I just vary slightly the way my Lord Justice Lewison put it? The employer says, I have a disabled employee who is underperforming. We have a forthcoming reorganisation in which we will have to make redundancies. Can I make him redundant? Or can I select him in the redundancy? You say that is the furtherance of iniquity.
It depends on the client's motivations. If the client wants to dismiss him because of the Protected Act and is using the lawyer as a means or a tool to achieve that end, I do say that if the discrimination is serious enough, then that is legal advice in furtherance of iniquity.
But how would one know at this stage? I mean,
Well, there has to be a strong prima facie case. So, I mean, there could be all sorts of employment disputes where one might speculate about whether there was legal advice given in furtherance of iniquity, but it's never going to go anywhere unless there's a strong prima facie case that the lawyer was used in furtherance of iniquity.
But you say it's iniquity for an employer to select on the grounds of redundancy somebody who has made a protected act.
That's not quite my submission. My submission is that it's iniquity to behave in a way which is entirely contrary to public policy. And
That's painting with a very broad brush, isn't it? And it might be said it's contrary to public policy for people to use stolen documents. How does one know?
it's not a phrase I've invented, it's one which I've taken from the cases.
I've recorded that. It is iniquity to act in a way wholly contrary to public policy. That's the submission.
That's the submission.
All right.
And the principal authority is Eustace, and I also rely on BBGP and Babcock. I think it's paragraph 62.
Yes. Those are the two authorities you want us to look at.
The way the issue has been framed is dishonesty a necessary ingredient?
Yes.
Perhaps if I could address that point, and in the course of doing so I can refer your lordships to the entirely contrary to public policy test.
Yes.
I'm conscious of the time. I was hoping not to have been this long. I apologise.
No, I was hoping we'd finish by midday, but well, it is as it is. How much longer do you think we're going to be?
I think about 15 minutes.
Very good. Thank you very much. 2 o'clock.
Likewise.